Good afternoon, everyone. My name is Marissa Hoffman, and I am an advocate with Community Legal Services of Mid-Florida. Welcome to the Housing Rights in the Era of COVID-19 presentation presented by Community Legal Services of Mid-Florida, Orange County Government, and HUD, the Department of Housing and Urban Development. Today, we have two presenters here with us. The first is Mr. Jeff Hussey. He is the Director of Litigation and Public Interest with Community Legal Services. And next, we have Ms. Yesenia Negron. She's the Federal Grant Administrator for Orange County Housing and Community Development Division. If you're all ready, we'll get started, and you'll hear a little bit more from our presenters in just a few minutes. Here's our presentation outline. So today, our presentation is in 4 parts. The first part will discuss COVID-19 and housing issues that are relevant today. The second part will address landlord-tenant law and some common questions, topics, issues, and concerns that residents of Orange County frequently have. The third part is a discussion of Orange County resources. And part number 4 is a discussion of fair housing law. These are the topics that will be covered today during the presentation. And here's a brief overview. As part of Orange County Housing for All's initiative, Orange County government partnered with Community Legal Services of Mid-Florida to conduct workshops for residents in all districts. And here you can see that the workshops will cover the following information: COVID-19 and its effect on housing, your rights as a renter/tenant, a landlord's responsibilities, preventing evictions, housing discrimination laws, and information about housing and health programs that are available in Orange County. At this time, I would just like to take a moment to please remind and ask you all, if you haven't already, please complete the pre-webinar survey, also called the questionnaire, before we begin our presentation. If you haven't already done so, the link is listed a few times in our chat feature within the webinar platform. This survey assists Orange County residents by informing policy development, assisting with strategic planning and resource allocation. And I'll also take this moment to just inform you that there is another survey available at the end of the presentation. This is a separate survey. We do ask, please, that you complete both of these. Again, they are a very important tool for residents of Orange County to inform policy development, strategic planning, and resource allocation. If you could please take the time to complete both the pre-presentation quiz and the post-presentation quiz, myself and both of our presenters would greatly appreciate it. Our first presenter today is attorney Jeff Hussey. He works for Community Legal Services of Mid-Florida. Jeffrey Hussey has been practicing law in Central Florida for the past 30 years. He worked in the private sector litigating for more than 25 years and has been involved in public interest law for the past 3 years with Community Legal Services of Mid-Florida. Jeffrey Hussey was recently promoted to the Director of Public Interest Law and Litigation with CLSMF. Take it away, Jeff.
Good afternoon. I want to thank everybody for being here. Originally, we were hoping to do these presentations live, but COVID changed things drastically for all of us, so we appreciate you taking the time to register and participate here today. COVID has affected pretty much everybody on this planet, and one of the hardest hit areas, obviously, are people who are renters. And lots of people have lost their jobs, they've been furloughed, they haven't been able to pay their rent. So part of this webinar today is to try and help you through that, help people through that, learn what their rights are, what landlords must do if they are going to try and evict you. And the clock is ticking, unfortunately. We have 10 hours until the moratorium on evictions is set to expire, unless Governor DeSantis extends that extension. It is set to expire at midnight tonight, and starting tomorrow on July 1st, landlords can start the process of trying to evict you from your housing if you've not been able to pay rent. Unfortunately, The fact that you may have even suffered from COVID-19, lost your job from COVID-19 does not excuse you from paying rent and will not prevent you from being evicted from your housing. And that is what we want to do today, is to kind of lead you through what may happen, the proper steps that must be taken if someone is going to try and evict you from your housing, and possibly give you some tips or some suggestions of how to prevent the eviction even if you haven't paid your rent for the past several months. The first thing I want to stress, and this goes for if you haven't paid your rent or if you're behind on your mortgage, is communication. Um, you need to reach out to your landlord, to your mortgage holder, to try and work out some type of arrangement that will keep you in your housing to avoid an eviction or a foreclosure. They are not going to reach out to you. You need to reach out for them. And one of the most important things to do before you even do that is you need to figure out what you can and cannot afford. You don't want to start negotiating with your landlord for a possible repayment of back rent and rent going forward at an amount that you cannot afford, because you're going to be faced with that same situation where you're possibly going to be subject to an eviction. If you are successful in negotiating with your landlord, the best practice is always to try and get any agreement in writing, and it may even be where you have to sign a new lease. You want all the agreement in writing, so it's enforceable by the landlord and by you if there's an issue. Before you sign anything, what you want to do is you want to get all the most current information you have with regards to how much money you owe, any late penalties they're seeking for non-payment, and those are all things that you can use to try and negotiate. Lots of landlords will potentially waive the late fees because they understand what's going on. But what everyone needs to remember is most landlords have to pay bills as well, and they pay bills with the rent they receive from their tenants. So they're entitled to collect the money from you because you entered into a lease agreement to live there, and that lease agreement lays out the terms of the amount of rent you're to pay each month. So I think, and I'm hoping that this is going to be the case, that landlords will work with tenants, because the eviction costs money. They have to pay for lawyers to draft all the complaints and all the paperwork. They have to pay them to go to court. They have to pay to get served. So it's not an inexpensive or free process for them. So I'm hopeful that landlords will rather negotiate so they get money in their pocket rather than having money go out of their pocket to pay for lawyers, court fees, service fees, and things like that. But once again, it's communication. You need to get with them to discuss possible arrangements to pay your back rent and your rent going forward. As I said earlier, if you lost your job, if you have complications due to COVID-19, you're responsible for not only your rent, but the late fees. We would hope that landlords would be understanding of the circumstances, but there's nothing by law that requires them to waive late fees, to enter into any type of agreement or payment plan for back rent. This is all voluntary, but once again, the communication aspect, talk to them, see if you can get something worked out. We've heard a lot about the CARES Act, and the CARES Act provides some additional protections for individuals, but what a lot of people don't realize is that the CARES Act only applies to housing that has some type of federal connection to it. That type of housing programs could be public housing, Section 8 housing voucher programs, HUD subsidized family or senior housing, USDA housing, low-income housing tax credit, private housing where the individual may have a mortgage that is backed by the federal government, HUD, including FHA mortgages, USDA mortgages, VA mortgages, and mortgages that are backed by Fannie Mae or Freddie Mac. These provide extra protections. The most that you'll see is, with regards to the mortgage, is forbearance, which is a extremely important benefit if you can get a forbearance, because that is going to basically forgive you or not foreclose on you for a certain period of time for not paying your mortgage, but those missed payments will be put on the back end of your mortgage, not due and payable once the period of forgiveness ends. Evictions under the CARE Act. Your protections that you get under the CARE Act, if you're in one of these federal tied programs, is you get an extension. Basically, the moratorium, that's what you hear locally, is the moratorium in the state of Florida. But under the CARES Act, they have a moratorium for unpaid rent until July 5th, 2020. Once that date comes, then the landlord must give you at least 30 days notice before filing an eviction case in court. And that is a significant increase from what state law applies. And we'll discuss that later, the notice requirements under state law. But 30 days is a significant amount of time in eviction cases, additional time that you're going to get. Your landlord can still file an eviction lawsuit against you for other reasons, such as you violated conduct terms in your lease, or you have unauthorized guests, or just certain lease violations are not protected under the CARES Act. It is the non-payment of rent. We're going to go into this in greater detail when Yesenia speaks about the services and what's out there to maybe help you with rent payments or utility payments, or even rapid rehousing if needed. One number I want everyone to remember if they find themselves in that situation is 211. That is the Heart of Florida United Way, and that is the entry point into getting services from many, many different agencies that are out there to try and help people through this crisis. The second part I want to go over is just some general landlord-tenant law. This is not meant to be a deep dive into the law. This is not meant to cover each and every scenario under landlord-tenant law, but it's just to go over basic rights and obligations under Florida landlord-tenant law. The main thing that I want to stress is that what I'll be going over is Florida law, and it applies both to landlords and tenants. And the main thing I want to make sure is people know what their rights are. In fact, if they are suffering from an eviction, they've been served with an eviction, what their rights are, what they must do, and what potential defenses they may have. The first thing that people want to know is my lease valid? Does it have to be in writing, or can it be an oral lease agreement? It can be both. Obviously, the best practice is to have everything in writing, because that is the formal agreement and it outlines everybody's rights and obligations under that agreement. You need to make sure you keep a copy, because what's contained in that lease is what you must abide by. These are generally what things you want to see in a lease: the terms, the names, the limits. If you ever rented any type of apartment complex, these are pretty much standard, and the National Apartment Association does have standard rent agreements that people enter into. One of the things that we at Community Legal Services, which is we're a local legal aid society, one of the main things that we get calls on is housing conditions that are substandard or things that need to be fixed. Under Florida law, the landlord is required to maintain the roofs, the windows, the screens, the doors, the floors, the steps, the porches, walls, foundations, and keep all other structural components in good repair and the plumbing in reasonable working condition. Landlords are not required to maintain mobile homes or other structures that are owned by the tenant. So if the tenant puts a shed in the backyard, they're responsible for the upkeep in that. In apartments, the landlord also has to make provisions for extermination, locks and keys, clean and safe common areas, garbage removal, running water, hot water, and this is one, heat. There is no requirement for landlord to provide you with air conditioning or a working air conditioning unit, but there is a requirement for the landlord to provide you heat. So if your air conditioner goes out or you don't have an AC in your unit, you cannot compel your landlord to put one in. You do owe duties to the landlord as well. As I mentioned earlier, the terms of the lease controls everything really about your living situation in that apartment complex or that house that you're renting. You must pay your rent when it's due. You must keep things safe and clean. And another problem that people run into sometimes is they have guests who may violate those rules. You are responsible for any conduct or any damage that your guests may do if they come onto the premises. Another issue we see a lot are landlords that don't announce or don't give you any warning beforehand coming into the unit. By Florida law, a landlord must give you reasonable notice before they move in, or not before they move in, before they come into your apartment to make any inspection, any repairs, any maintenance issues. What is reasonable notice under Florida law is 12 hours. And what is a reasonable time? Reasonable time is usually between 7:30 and 8 p.m. The landlord can come into your apartment or your housing without giving notice if there's an emergency. And what's an emergency? Usually it's for the protection or preservation of the unit. If there's a fire, if there's a gushing leak coming through or water escaping, things of that nature, they can come in without giving you prior notice. If you're gone, Florida law says you're gone equal to 1/2 the time of the periodic rental payments. A landlord can come in to make sure that it basically do a wellness check and make sure everything is okay in the apartment. Best practice is if you're going to be gone for any length of time, to advise the landlord, let them know. Once again, in writing is the best thing to do. Okay, the other thing we see a lot is the landlord's not fixing things, or we have roach infestations, or we have rodents that are getting into the apartment complex. Can I make the landlord fix those things, and how do I make them fix it? And the most common thing is what you hear is withholding rent. And you can always withhold your rent if there are problems, but there are certain requirements that must be met. The first thing is your rent must be current. So if you're behind on your payments because you lost your job due to COVID and you have rats that are coming into your apartment and you don't want to pay your rent for July, if you haven't paid your rent the last 3 months, you cannot withhold your rent. So that's something you have to remember. You can't use that as a excuse going forward to not pay your rent. The repair must be something that the landlord is obligated to take care of. You must provide your landlord with written notice with the opportunity to fix the problem. And this is the key thing. If in normal situations where we're not dealing with pandemics and you're just not paying this month's rent because you need these repairs, you need to hold on to the rent. And why do you hold on to the rent? Because if you don't and they fix it, you have to pay that rent. If you don't have that rent to pay, then you can be subject to an eviction. You have to give, you may withhold your rent based on the 7-day notice. You can fix the problem yourself and deduct the repair bill from your rental payment. That could result in litigation. It could result in you having to go to defend your actions in front of a judge to avoid an eviction. So keep all receipts. Another thing, if the problem is something that potentially is a code violation, it's always a very, very good idea to call the local code enforcement. Have them come document what they have, and that's great evidence for you of why you're withholding your rent. How do you withhold it? There are forms that you can get from off the internet through the state of Florida. You can contact Community Legal Services. You can go to our website. We're downloading forms, but it's a simple letter that's given 7 days to the landlord to fix the problem. So why is 7 days important? You could not send your landlord a letter today, a 7-day letter today to withhold your rent for tomorrow. It has to be 7 days before the rent period is due. Best practice is to send it to your landlord versus with certified mail, and that way you know he got it, and always keep a copy for your records. As I just mentioned before, yes, you must pay back the rent if you withheld it and the landlord fixed the problem. If you don't repay the landlord, you don't come current with your rent, then they can go through the eviction process. Okay, this is kind of the most important thing that I want to get across today about the eviction aspect of what must happen and what can't a landlord do. An eviction is a legal process. A person cannot be evicted from their home or foreclosed from their housing if they haven't paid their mortgage without a court order. I've heard stories across the country of what's called self-help evictions, and it's a tactic that landlords are doing. They're getting frustrated because people have not paid their rent in several months, and they want them out of the property. I've heard landlords remove doors. I've heard landlords put locks on the door so people can't get out or get in. These are all practices that are prohibited. Um, the only way to legally remove you from your housing is with a court order. The 7-day notice if you're withholding the rent for repairs and your landlord tries to go through with an eviction without doing the repairs, and that is what's called a defense to your eviction. Okay, here is the eviction process. If you have not paid your rent and COVID has forced you to basically abandon your job because your job may be shut down, the landlord in this right now they are not doing this, but in another half day they can start doing this. They'll serve you what's called a 3-day notice. What a 3-day notice is telling you how much money that they feel is due and owed to them, and that you have 3 days to come current with your back rent, or they will start with the eviction process. There's also what's called a 7-day notice, which does not apply to non-payment of rent, but instead that applies to lease violations. For instance, you're playing loud noise at night and your landlord has given you what's called a 7-day notice to stop playing loud noise at night. If you do it again, we can evict you. If you perhaps have not pay, or you have too many vehicles allotted for your parking place, they'll tell you remove one of those cars or you'll be subject to an eviction. That's called the 7-day notice, which is different from the 3-day notice for non-payment of rent. If you don't come current with your rent within those 3 days, or you don't comply with the 7-day notice, the next step is for the landlord to file a complaint for eviction. And this is a formal legal process that is first filed in the court. It's first filed in the court, and then after it's filed, the court's going to issue what's called summons, and that summons has to be served on you as a tenant. And this is the most important date to remember, is once you get served with that, you only have 5 days to respond. If you don't respond within 5 days, your case is over. The judge can issue what's called a default judgment against you, and you're on the way to losing your housing. If your eviction is for back rent that you have not paid, under Florida law, you must pay the amount of back rent that they are claiming is owed, or you don't get to present any defenses. You'll get what's called a default judgment as well. If you think that the money that the landlord has put in the 3-day letter and in the eviction complaint is wrong, you can dispute the amount and do what's called a motion to determine rent. However, if you do owe the back rent, you have to still deposit the amount of money that you feel is the correct amount, not the amount that the landlord thinks. If you don't do that, you'll be subject to the default judgment, and you'll be on your way out of the housing. So it's very important. That's the only way you can get in front of the judge if you have back rent that is owed. What are some of the defenses that you can raise to an eviction process? One, the landlord refused to accept your payment. You tried to go into the rental office and he wouldn't accept your check. The best defense is the landlord accepted your rental payment in full. The landlord failed to provide you with a 3-day or 7-day notice. The notice is something that is a requirement under Florida law that they must attach to the complaint. It's a technical defense, but it's one that buys you time and can get the case dismissed. The landlord failed to prepare the unit pursuant to a proper 7-day notice. The landlord, as we talked about earlier, is requesting a wrong amount of rent due. And another possible one is the landlord's including late fees that are not rent. It's important you have to raise your defenses when you respond to that eviction complaint. So that is one of the services that we can help people out with at Community Legal Services if you qualify for our services. One of the common things that we see in people who are trying to represent themselves and they file their answer on their own are, I need more time because I lost my job, or that my boss decreased my rate of pay. That's not a defense that's going to save you from an eviction. Some people have roommates, and their roommate may have left the other person high and dry without paying their share of the rent. That is not a defense to an eviction action. The landlord failed to make repairs without a 7-day notice. If you don't have that 7-day notice, you can't raise that as a defense. And unfortunately, you could be in the hospital. You could have a medical emergency. That is not a defense to an eviction action. If you get served and you file your answer and you put your money into the court registry, you will have a hearing in front of a judge. Now, what that hearing is going to look like going forward, we don't know. The judges are conducting hearings with webinars like this, with Zoom platforms and other different types of platforms. Let's hope that one day we can get back in front of judges and in courtrooms and see each other personally. But I suspect in the near future we're all going to be doing it virtually. But the judge is going to hear your case. The landlord will put his side of the case on and explain why they're filing the eviction, and then after that's when you would have the opportunity to explain to the court what your defenses are, why you don't think the eviction is proper, present any evidence that you may have, any documents that you have. Just important tips is to always be respectful to the court, address the judge as your honor, always dress appropriately. If your landlord wins, if they win in court and get that final judgment, the landlord has to get what's called a writ of possession issued, and that can only be issued by a judge. And the writ of possession is the last step in the legal process of removing you from your housing. Once that writ of possession is issued, the sheriff will come post that on your door, and you have 24 hours to move out. If you're not out of that housing within 24 hours, the sheriff can come physically remove you, padlock your door. Some landlords can go so far as issue a trespass warrant against you for still being in that housing. They can, if you're still there after 24 hours, they can make you leave without even getting your belongings. The landlord can even impose a lien on the belongings up to the amount of rent that is due. But once that writ of possession is issued, it's very difficult to go back from that point in time. Not impossible, but very difficult to get a judge to withdraw or cancel that writ of possession based on some type of emergency. So it's important to try and prevent that writ from getting issued. I talked about this a bit earlier, but landlords cannot try and get you out of your housing without going through the courts. And this is what's called self-help evictions. Landlords have been known to do this, and this happens locally. Shut off utilities, change locks, remove doors, windows, roof walls, or windows. Actually take property from your home, or putting padlocks on your door so you can't get inside your apartment. Those are all called self-help evictions that are illegal under Florida law. If you suffered from a self-help eviction, if your landlord tried to get you out by changing the locks or shutting off your utilities, turning the water off, you may be entitled up to 3 months of rent as damages. And that's a way to basically punish the landlord for doing these illegal type of activities. To get those, just to back up real quick, to get those 3 months of back rent as damages, you would have to go through the court process yourself. So that's not something that's an automatic. A lot of people want to terminate their leases, especially now, if they've had a reduction in income and they can't afford their lease going forward. What type of notice you must give? Leases also have natural ending points. For natural ending points, if you're not going to renew your lease, you have to give what's called proper notice. And outlined in the slides are what proper notice are. If you're paying week to week, it will be 7 days. If you're paying month to month, it's 15 days. If you're paying quarterly, it's 30 days. If you're paying annually, it's 60 days. So you always want to, if you're not going to renew your lease, send them a notice within 60 days. If it's a year-long lease, in writing, keep a copy, and ask for a receipt. A lot of people have to break their lease before the time's up. The ways that you can do it legally: military service, there are code violations, and it's a safety hazard for you to continue living in that property. or your landlord is violating some type of privacy or harassment. Those are all valid grounds to break your lease. That doesn't mean the landlord's just going to let you walk without trying to get something from you, but those are legal defenses to breaking your lease. If you want to break your lease before the time's up without a valid reason, then the landlord can try and hold you to the amount of rent that is still left in your lease. Many landlords will work with you though. And so once again, that communication, if you need to break your lease, especially if it's because now you can't afford the rent going forward because of COVID has cut your pay in half, tell your landlord that. They may even be willing to renegotiate your lease terms, or they may let you out without having to pay any type of penalty. Most lease agreements have either have penalty provisions in there. You need to read your lease to find out what the penalty is for breaking early. Probably the second most popular question we get is about security deposits and how do I get my security deposit back? In Florida, landlords must tell you if they want to keep some or all of your security deposit. If your landlord plans to keep your deposit, they must send you a notice by certified mail within 30 days of you moving out. So when you move out, you must, absolutely must, give your landlord a forwarding address of where they can send the check, where they can send the notice, where they can reach you at. If your landlord is not planning on keeping any of your security deposits, they have 15 days to give you that deposit back in whole. As I stress, always get that new address to the landlord. You may feel uncomfortable doing that, but if they don't know how to reach you, then they have no way to forward you any information or any money that you may be owed for your security deposit. Okay, we had a couple of questions, at least one that came in through the chat before we get to Yesenia, who's got more positive news than me. The question is, if there's somewhere to find out if my landlord has a federally backed mortgage on a single family residence. That's a good question, and I'm trying to think of what the answer is. How about this? I'll give you the best answer is this: to contact Community Legal Services. You can contact our helpline, and that number is 800-405-1417. That is our helpline. Lawyers will be answering the phones there. We're open 5 days a week, Monday through Friday. They have access to various different databases that can probably get that information for you. I would strongly encourage you to contact that number, and they'll be able to provide you the assistance. I think we have one more question. Who is responsible for legal fees during an eviction? Okay. To file the eviction, that's going to be the landlord's responsibility. The landlord's going to have to pay the filing fee. Landlords don't have to get a lawyer to file an eviction, but most do. But they have to pay the lawyer, they have to pay a filing fee, and they have to pay a service fee. And that's the person who comes out and serves you with the eviction complaint. If you do not respond to the eviction or you lose in court, most eviction complaints, if not all of them, if a lawyer has filed it on behalf of a landlord, are going to seek to get their attorney's fees reimbursed by you, the tenant who's been evicted. And that would be part of the final judgment, would be an awardance of attorney's fees. I could not give you a specific number as to how much a judge would award a person an attorney's fees, because that is a case-by-case basis, and different judges award different amounts. The final question I have is, if a tenant does not pay rent, can the landlord keep the security deposit? The landlord will go through the eviction process, and they will have to get that final judgment and that writ of possession, and they still have to go through why they're holding on to security deposit. They have to give you notice, and you have the ability to challenge it. I can tell you this: if you have not paid your rent, the landlord is going to hold on to that security deposit. And if you want to challenge it, you will have to take them to court to get that money back. They are going to hold on to it. Another question, will landlords' late fees be considered during COVID-19? I guess be waived. They don't have to waive them during COVID-19. A private landlord, it's under his discretion. We hope that landlords would waive those late fees because we're all in this together. I would hope that a landlord would not try to evict you if you can pay your rent, but maybe not the late fees, to keep you in your housing, because that's the most important thing, is to keep people in their housing during this crisis. So if the landlord holds on to your late fees, once again, or not your late fees, your security, I'm getting the questions messed up. The late fees. Once again, the communication. Talk to your landlord. If you can pay your rent, but let's say you're going to be a couple of days late, talk to them ahead of time and say, hey, I'm going to be late with my rent. Can you waive the late fee this month? I just got back and we're not back to work, and my employer's not going to pay me on the 31st. They can't pay me until the 5th. If you have valid reasons, talk to your landlord. If you can get it in writing, that's even better. I'm checking to see if we have any more questions. Question is, what if you're not under a lease? How can a landlord collect fees? That's an interesting question. I guess, well, if you're paying rent or you're paying money to live somewhere, then you either have a formal lease agreement that's oral, or you're just, I don't want to say squatter, but let's say you're just staying in a room. They still have a way to get you out, and that would be an unlawful detainer, and that's another court process that they go through to remove, let's say, a roommate who's not on the lease but won't leave. So there is a way how they can collect fees against you. That's going to be a little bit tougher, but if they engage a lawyer to do that, they can always ask for fees as part of the damages. What should you do if you're a victim of a self-help eviction? Call Community Legal Services Mid-Florida would be my first suggestion. We have a housing unit, and those types of cases are ones that we like to help individuals with and take great pride in helping individuals with. And once again, that gateway number to get in would be 800-405-1417. If you're part of a self-help eviction, you have to go to court and you have to challenge them. Not saying you have to have a lawyer, but our services are free. So I think it truly helps to have a lawyer at your side to draft all the appropriate pleadings, to make sure that hearings get set in front of the judge, and to hopefully get you those damages that you deserve for the self-help eviction.
Okay, and now we have our second presenter, Ms. Yesenia Negron. Yesenia is a federal grant administrator for Orange County Housing and Community Development Division. Yesenia oversees all aspects of the Community Development Block Grant and the Emergency Solutions Grant, which aids our local community in addressing social issues related to housing, homelessness, and public services. Ms. Negron is the county's lead fair housing coordinator, thus allowing her to build strong community partnerships and initiatives in order to combat housing discrimination throughout Central Florida.
Good afternoon, ladies and gentlemen. I would like to thank every single one of you for taking time out of your busy day to sit on this webinar with us and learn a little bit more about your housing rights and what available resources are out there for you to help your own self and to also be able to refer someone who is in need. This part 3 of the webinar, we are going to be discussing Orange County's response to the COVID-19 pandemic. And in doing so, our objective is to provide an overview of the CARES Act. Also, we're going to be talking about how can our residents access the coordinated entry system, which is the point of entry for the whole entire region for those individuals that are seeking public assistance and rental assistance, any form of referrals within our nonprofit organizations. We're also going to be highlighting the COVID-19 health and public safety actions that the county is taking and the COVID-19 testing sites. This is really important for those of you who need to know where these testing sites are located, and we're also going to have some additional resources. As you all know, March 27th, the Coronavirus Aid, Relief, and Economic Security Act, the CARES Act, was signed into law by the federal government. This provided more financial assistance to local governments such as Orange County. We've received $243.2 million in CARES Act funding, of which 30% was allocated for small business financial assistance. The other 30% was for social services and community needs, which is $72.9 million, and that's what we're really going to be emphasizing on during the webinar. And the rest, the 20% public safety and health expenditures, and we also are targeting other areas, but for the purpose of this webinar, we are going to focus more on the social services and community needs and what funding streams are being allocated to the Housing and Community Development Division of the county. It's really important to note that the $72.9 million that are being allocated are geared towards individual and family assistance programs and direct assistance to social service agencies. We know that the current housing crisis that we're experiencing is something that was already existing prior to the COVID-19 pandemic. However, it has been intensified 10 times by the current pandemic. And so we can't do the work in Orange County alone. We need the assistance of our regional partners. We need strong collaborations. And this is one of the reasons why we put together this webinar. We're going into formal contracts with all these nonprofit organizations, such as Community Legal Services of Mid-Florida, to be able to address a lot of the concerns that our constituents are having and merge the gap in services. So these organizations will work directly with the county to provide continuity of service for residents seeking assistance with homelessness, mental health, substance abuse, food pantry, job retention, and childcare. So for under the Individual and Family Assistance Program, this is basically the program that you have all seen circulated through social media and different news outlets stating that the application process is going to be open for our constituents to be able to apply for funding for rent, mortgage, any related expenses to health. So we do want to let our residents know that right now that application process is closed. Mayor demonstrated yesterday during his press conference that there is a projected date to reopen the Individual and Family Assistance Program by July 13th. We are hoping to be able to process the rest of the applications that were submitted. We received about 30,000 applications, and 8,000 of those applications have been approved. We know that the demand for this program has been overwhelming. Orange County is still processing the applications, and we ask for all of our constituents to please, be patient. I know this is a very difficult moment for everyone, especially if you have children in the household and you have to pay your rent. With this program, all households will be able to receive up to $1,000 for assistance that has to do with rent, mortgage, medical, or any eligible expenses. If you want to know specifically when the application is going to reopen, we ask that you follow us on social media, go onto Facebook, Twitter, Instagram. Please visit our website at www.ocfl.net/orange cares. Make sure that every single day you're going on there and just seeing what else is new. We're living in a current moment that everything is changing so drastically. So much information is being disseminated to the community, is being filtered down through various levels of government. So we want to make sure that you know where you need to go to access the up-to-date information. In addition to this funding, the Department of Housing and Urban Development, HUD, allocated $6.1 million in funding to the Orange County Housing and Community Development Division. This is amazing news because it's going to be able to provide other forms of financial assistance to the community that otherwise wouldn't be accessible to them. So under the Community Development Block Grant, we're going to be allocating $4.1 million for public services supplies, materials related to COVID-19, and over $2 million are going towards the Emergency Solutions Grant. This is going to be able to fund COVID-19 needs in regards to homeless services in the community. Like I mentioned before, community partnerships is an important component of the work that we do. We cannot address the current pandemic working in different silos. We have to approach the issues within a halo initiative, basically a unison, something that is cohesive. So in order for us to do this, we are going into formal contracts with all of the nonprofit organizations in our region that have applied for COVID-19 funding. These nonprofits are specifically focused on assisting community members who are low to moderate income. These activities include health and safety improvements, emergency shelter and staffing needs, affordable childcare, legal services and clinics, and this is where community legal services comes in. We're also going to be providing rental assistance, services for at-risk seniors, which is really important. We know that they are one of the most at-risk community subpopulation groups within the COVID-19 health disparities. So we're also going to be talking about job readiness and retraining, because this is something really important for us to focus on, given the fact that a lot of people have lost their employment. Under the Emergency Solutions Grant, the activities are going to focus more on assisting individuals who are homeless and families who are homeless. These activities include emergency shelter operations. All of our shelters in our region are going to be receiving CARES Act funding to expand their services and to abide by the social distancing guidelines. They are going to be able to hire more staff to provide more referral services. We want to ensure that we're prioritizing homeless prevention services as well. And this is really important, especially now that we're looking into the moratorium on evictions being lifted, and rapid rehousing services as well. This is going to be able to help our constituents with first month deposit, rent arrears, utility deposits. According to data released by the Heart of Florida United Way, 61% of the calls right now, as of June 28, 2020, 61% of the calls are related to housing, emergency shelter, and utilities. So this really tells us that there's a huge gap in our community, and the funding that is being allocated by HUD is going to help us meet this criteria. You're probably wondering, okay, I've heard a lot about, eviction protections, what my housing rights are. Now I'm hearing a little bit about and learning a little bit about the services that Orange County are going to be providing to the community, but how can I access these services? So we are going to be giving more monies to Heart of Florida United Way so they can expand their 911 call center. Heart of Florida United Way is the main point of entry within our coordinated entry system. Residents have to call 211 to receive a referral to one of the nonprofit organizations to be able to request the assistance. Also, we're going to be having hubs opening in July 10th. The first hub that's going to open is going to be located in the United Against Poverty facility at the West Michigan Street. We have the address up on the slides. This hub is going to be open from 1:30 p.m. to 4 p.m. It's really important for people to know that the hub, the office hours are open they're ideal for individuals who are experiencing homelessness, but also it's also open to anyone experiencing homelessness, right? So it can be a family experiencing homelessness. So if they want to sit down with a certified housing counselor, this is one of the hub locations that will open starting July 10th. The COC, the regional, our regional partners, they've implemented mobile access points as well to be able to facilitate individuals accessing the services. So what are mobile access points? They are they're locations where diversion conversations and assessment take place. They take place in a flexible environment with trained workers to explore alternative resources and support. This helps to keep individuals off the street or out of shelter. So basically, they're sitting down with individuals who are experiencing homelessness, who are at risk of homelessness. They're helping them identify other means of housing that does not have to be shelter. So do you have a family member in the region that you can possibly go to? Do you have a friend? Do you have, any support system in place? And this diversion program, the regional diversion program, has proven to be very, very effective in reducing the amount of people that are entering shelter, because as you all know right now, our shelters are operating at full capacity and they have to continue to abide by the social distancing guidelines and making sure that everyone is 6 feet away. They have to abide by the quarantine guidelines. So we are continuously providing technical assistance to our shelters on how to better assist our constituents, especially individuals who are experiencing domestic violence and families with small children. So the mobile access point is going to be located at the First United Methodist Church in downtown Orlando. They are going to open on July 9th from 9 a.m. to 12:30 p.m. and also Thursday, July 23rd from 9 a.m. to 12:30 p.m. So please mark your calendars. Once again, if you know anyone that can benefit from the mobile access points, feel free to refer them. Something very important as we continue to tackle the housing crisis and the COVID-19 pandemic, please continue to abide by the health and public safety actions that the county and our regional partners are implementing. This helps to decrease the daily positive rates of infections related to COVID-19. Honorable Mayor Jerry Demings signed an emergency executive order on June 24th requiring all Orange County residents to wear face coverings. So if you're out in public, please wear your face coverings. Also, our regional partners, everyone that is involved in the coordinated entry system, all of our homeless providers, they're also requiring all clients to wear face coverings and hand sanitizers and practice social distancing, even when they are doing the mobile access points or the hubs, in-office meetings. I know a lot of our nonprofit organizations, our regional partners, have moved all of their services, the majority of their services, to an online platform to be able to accommodate the need. In order to limit the probability of continued spread of COVID-19, all homeless providers and clients are recommended to abide by the health guidelines, which means social distancing, face coverings, as mentioned before, hand washing, when acquiring or providing services. This is really important because we know that individuals who are experiencing homelessness are considered high risk with health. They probably their nutrition are not up to date. So we want to be able to help them. And some really, really good news, the Economic Recovery Task Force, they started the PPE initiative these past several months, and they've been able to assist our local businesses in acquiring over 5 million face masks, over 750,000 hand sanitizers. Community members have been able to access over 1 million face masks and 55,000 hand sanitizers. These protective equipment is being distributed throughout the county. Once again, if your local nonprofit organization, your small business need to access these services, please visit our website. testing sites, the COVID-19 testing sites are taking place in various districts and different points throughout Orange County. And I really commend all the people that are in charge of the coordination of the testing sites because they're trying to expand more on the location. So if you want to know where the testing sites for Orange County are, please visit www.ocfl.net/forward COVID-19. I know that the city of Orlando, they have mobile testing sites and they rotate on a continuous basis. So please visit their website that is up on the screen. And the One Blood Center is also providing antibody testing. So if you go in and you donate, they can test your blood for antibodies for COVID-19. We do ask that you complete, first you register, you do an appointment. That way you are serviced and you're not having to wait long periods of time. Where can you go to obtain more information about eviction protections? Well, if you visit our website, you will see that we've developed some video segments and also some facts in Spanish, English, and Creole to be able to service our different language, individuals that speak different languages in our community. Also, if you go on to the Community Legal Services website and check out their housing tab, you'll be able to find out more information about your housing rights. Once again, Community Legal Services Helpline is 1-800-405-1417. And with that, I do want to stress that we are working very diligently behind the scenes. We have different divisions within the county, providing technical assistance to our nonprofits and our other regional partners. We're going into these federal contracts with these agencies because the work that needs to be done cannot be done by government alone. We need the assistance of our regional partners. And I am very confident in the work and the abilities that they have to be able to assist our community. If you want more information, once again, please follow us on our social media platforms. Thank you.
Thank you so much, Ms. Necrom. And now we have Attorney Jeff Hussey.
I want to go over real quick, once again, before I start on my fair housing aspect, I want to thank Orange County and all the work that they've been doing. They've been very proactive and trying to stay one step ahead of this virus and providing some great services to the residents. So a shout out to them for that. Fair housing is a federal law and it's also been adopted by the state of Florida. It's put in place to protect your civil rights in housing. And unfortunately, we're seeing and hearing about certain instances where people's civil rights are being violated due to COVID-19. And before I get started, I wanted to play a quick video for you that I think is an excellent history of the Fair Housing Act and why and how it came into effect. And it's even more important given the times that we live in now. So I'm going to play that for you real quick and then I'll jump right back on.
Few in the nation believed that fair housing would in our time become the unchallenged law of this land. And indeed, this bill has had a long and stormy trip.
Well, I don't know what will happen now. We've got some difficult days ahead. Like anybody, I would like to live a long life. Longevity has its place. But I'm not concerned about that now. And I've looked over and I've seen the promised land. I may not get there with you, but I want you to know tonight that we as a people will get to the promised land. So I'm happy tonight. I'm not worried about anything. I'm not fearing any man.
Ladies and gentlemen, Martin Luther King was shot and was killed tonight in Memphis.
The death of the prophet of nonviolence set off the worst outbreak of arson, looting, and criminal activity in the nation's history. Washington's ghettos burned within a few blocks of the nation's capital.
The life of a man who symbolized the freedom and faith of America has been taken. And no words of mine can fill the void of the eloquent voice that has been stilled. But this I do believe deeply. The dream of Dr. Martin Luther King Jr. has not died with him.
President Johnson was willing to speak up and say, we have to pass a fair housing bill.
Hello, Mr. President? Yes, Dick. We're in trouble. We need some help. Yes? I'm afraid of that.
Federal troops, for the first time since the Civil War, took up positions to guard government buildings.
Nothing's probably touchier than your own neighborhood and your own home or your own apartment. The administration, which supported the bill, said this has no chance. The other stuff is okay, but this will kill any politician that touches it.
Well, I just could not live beside them. I don't feel that they should be oppressed. But I moved here because it was a white community. I have 2 daughters and 2 sons. And if there's too many colored people around here, I definitely will get out. I think that, well, the property values will immediately go down if they are allowed to move in here in any number.
It seems as though our country is pulling apart into separate societies, where whites have jobs and Negroes have unemployment, where the middle class lives in suburbs and the poor are left in the ghettos, where one group of Americans looks upon another group of Americans with growing mistrust and even dread.
Then the bill went over into the House Rules Committee, and under the chairmanship of the famous Judge Smith, a right-wing segregationist from Virginia, he wouldn't hold hearings on it. He would take the bill home so nobody could act on it, and we were running out of time.
Thousands flowed through the rainy streets of Memphis this day, finishing a march that Dr. King planned to lead in support of striking garbage workers.
How many men must die before we can really have a free and true and peaceful society?
Cause you're present, Lord. And I know you'll reach out and take mine. You take our hand.
The death of Martin Luther King is a tragic thing, but no legislation should be passed as a memorial to anyone.
In spite of the riots, I am going to support this legislation with all the vigor that I possess.
The laws that we pass up here are for all time. The Martin Luther Kings come and go.
The public reaction to this horror gave the sensible members of the committee a compelling argument that the House Rules Committee had to report that bill out. And I think that's how we got our bill. They just didn't dare bottle it up any longer.
And I have a dream that one day Negroes will be able to buy a house anywhere that their money will carry them.
at long last this afternoon. Fair housing for all is now a part of the American way of life. Democracy's work is being done, and the bell of freedom rings out a little louder. We have come some of the way, not near all of it.
The fight still goes on because we unfortunately have the laws, but we don't have the enforcement. That we have changed, but we still have the same kinds of discrimination.
The U.S. Commission on Civil Rights said today that efforts by federal agencies to end housing discrimination have been generally superficial or incomplete.
President Carter has ordered federal agencies to use all means possible to strengthen fair housing programs.
For the first time, people with disabilities and families with children will be protected from housing discrimination.
President Reagan signed legislation today designed to toughen up the nation's fair housing laws.
Why did you take part in this demonstration today? Just because there was a huge crowd, or did you have any personal reason?
Well, I took part in this march today because of Martin Luther King and what he stood for, because this march is what he died for.
You know what he stood for?
Yes. He stood for nonviolence and peace for all men of all kinds. And I think if he died for it, I could carry out what he started.
Okay, I just wanted to share that. I think that is a very powerful video, and it kind of shows you fair housing, how important it is, why it came about, and this was not universally popular. And unfortunately, I'm hoping we're not repeating ourselves of what happened before, but fair housing is the law. It is part of the Civil Rights Act. And it does protect you from being discriminated against in the sale, rental, financing, or insuring of housing based on your protected class. These are all the individuals that must comply with the Fair Housing Act. Private individuals, state and local units of government, lenders, appraisers, insurance companies, publishers, mobile home park owners and managers, and any housing providers or agents that are not exempted. When I say exempted, these would be the only individuals or groups that would not be covered under the Act. That's owner-occupied buildings with no more than 4 units, single-family housing sold or rented without advertisement, meaning that you stick out in front of your house a for rent by owner. You don't advertise it anywhere else. You would not have to comply with the Fair Housing Act. Housing operated by organization or private clubs that limit occupancies to members, religious organizations for non-commercial properties, and registered 55 plus and 62 plus communities. You can't discriminate based on age in those types of communities. What are prohibited actions? You can't deny a dwelling because of a color, person's skin, or their sex. You cannot set different terms, conditions, or privileges for sale or rental. You cannot provide different housing services or facilities. You cannot falsely deny that housing is available for inspection, sale, or rental, meaning that if a white person goes to an apartment complex and say, yeah, we have a 2-bedroom waiting for someone to move in, and then a person of color comes in and says, no, we don't have anything available, goodbye. That is a violation of the Fair Housing Act. Persuade owners to sell or rent to a protected class entering the neighborhood. That's called blockbusting. Steering a protected class to or away from a particular neighborhood, meaning you're looking for a house to buy and your realtor will only show you housing in a certain area because they think you'll be more comfortable in this area. That is a violation of the Fair Housing Act. Deny anyone access to membership in a facility or service related to the sale or rental of housing.
We are from different races,
cultures,
religions,
Our families are diverse and wonderful.
We have unique abilities.
And sometimes superpowers.
But we all have one thing in common.
The right to be free from discrimination
in obtaining and keeping our housing.
If you feel you are the victim of housing discrimination based on race, color, national origin, religion, sex, gender, familial status, or disability, contact us.
Okay, that was just a little plug for Vita Legal Service. We do have a fair housing unit and department who will investigate and, if necessary, file claims for you for violations of the Fair Housing Act. What the video touched on just real briefly are the protected classes, and that is race, color, national origin, sex, religion, familial status, and disability. Familial status, I'll touch on that a little bit in a minute, but that is if you have children under the age of 18. Orange County has some new and unique protections. They do have a specific part written in their code that protects the LGBTQ community. It prohibits discrimination based on gender identity. It prohibits discrimination based on sexual orientation. And it also prohibits age discrimination against anyone over the age of 40. Now, we're also hopeful, in the news recently, you might have heard that the U.S. Supreme Court granted civil rights to the LGBTQ community in employment actions. So it's our position that if they're granted rights in employment actions, then they should also be granted the same rights and protections under the Fair Housing Act. This is so new that obviously there are no cases that have come through that would explain whether or not it is or is not going to be covered. I think it will be covered. One of the things that the Fair Housing does, it protects people who are disabled. And disability under the Fair Housing Act is not a very strict standard. Basically, it is a physical or mental impairment which substantially limits one or more major life activities. You have a record of such impairment, or you're regarded as having such an impairment.
Everyone should have an equal opportunity to use and enjoy their home. Housing providers cannot limit you to what floor you live on or which amenities you can use, for fear of endangering yourself. If you are visually impaired, you can request a reasonable accommodation or modification from your housing provider. If you feel you are the victim of housing discrimination based on race, color, national origin, religion, sex, gender, familial status, or disability, contact us.
All right. Person who has a visual disability, especially if they are blind, that is an obvious disability that is going to affect a major life activity. Landlords would not be able to deny you having a C9 dog or a service dog because of that. But one of the main things we do see in fair housing are the requests for support animals. And you hear that the ESAs. And ESA does not have to be a dog. It can be a cat. It can be a parrot. It can be a ferret. It just has to be reasonable. If your landlord, if you have a support animal that you have a doctor's note for, your landlord cannot kick you out because of that. They can't say, well, your support animal is a pit bull or your support animal is a German Shepherd. We don't allow those animals in our apartment complex. Therefore, we're denying your ESA request. That is against the Fair Housing Act. There can be no weight or breed restrictions for an emotional support animal. One of the unfortunate things that we also see in community legal services is organizations or businesses that take advantage of people seeking emotional support animals by claiming that they can register their animal as an ESA and actually give you an emotional support animal card that you can carry around and present. There is no such thing as an ESA animal registry that is accepted by any government agency. So please, if you're looking for that, that is not something that's going to, a landlord has to accept or use to accept your ESA. It does require a letter from a healthcare provider or someone who knows about your disability.
Sam was recently prescribed an emotional support animal by her doctor. Sam's housing provider has a no pet policy. She was informed that she could have her animal within certain restrictions and pay a pet deposit. Knowing this is a violation of the Federal Fair Housing Act, Sam filed a complaint.
If you feel you are the victim of housing discrimination based on race, color, national origin, religion, sex, gender, familial status, or disability, contact us.
Okay. And if you're requesting an emotional support animal, that's what's called a reasonable accommodation. Once again, that's something that should be in writing. When I talked about protected classes, one of the things I said was familial status, and that's where this next topic comes in. I said if you have a child that's under the age of 18, if you're pregnant, you're also protected under the Fair Housing Act. But you must have one or more people under the age of 18. If you're pregnant, you can be a foster or adoptive parent. You could be in the process of adopting or becoming a foster parent, or you could be in households in the process of acquiring legal custody of a child under the age of 18. I've had cases here in Central Florida where a housing provider has tried to deny or would not renew a person's lease because the wife became pregnant and had a child. So we had to fight for them, and we won that one. So that is familiar status. The other thing, and let me back up real quick here. When I talk about reasonable accommodations, how this might come into play as well with COVID-19. If you suffered from COVID-19, let's say you had some severe medical complications and you might be discharged with a need for home health care, and your housing provider may try to deny you, saying that you can't have an extra person living in your unit, even if that is a nurse or home health care person. What you would need to do is have someone say that that is medically necessary for you to have that accommodation, and you would request to have an exception to the policy of no additional people living in the complex as a reasonable accommodation. And that should be granted. If it's not granted, then you should file a complaint. There are a couple of types of discrimination. There's intentional discrimination, and that's pretty obvious. You know, we don't want females here. We don't want people that color skin here. The more not common, and it's hard to explain sometimes, it's called desperate impact. And that the legal terminology is when neutral policy procedure has a disproportionately negative impact on a protected class. Well, what does that mean? I think it's easier to explain that by giving examples. One example would be that an apartment complex only allows people with full-time jobs. And this would bar disabled veterans or other people with disabilities who may not be able to work full-time, even though they can afford the apartment. What should the apartment complex do? They should instead consider all income to access someone's ability to afford rent. Another example would be that a lender has a policy of allowing its loan officers to overcharge consumers at loan officers' discretion. The result is that women are charged higher prices than their male counterparts, even though they both have the same credit profiles. What they should do is they should treat all people the same. And then one that is an actual case that did happen was in New Orleans after Katrina. There was money that was set aside by the government to repair properties that were damaged by the hurricane. Well, what they did was they did what the value of the property was and not the value of the house. So identical houses would be paid off differently. So those in the poor Black communities got much less money than those in the rich white communities, and that was found to be a violation of the Fair Housing Act. So that's what desperate impact is. Another protection you have is, and this unfortunately we're seeing more violence against women again during this pandemic, but if you live in federal housing, there's a federal act called VAWA, which gives you additional protection. VAWA is a law that was enacted to protect tenants from being denied assistance or terminated from federal assisted housing based on being a victim of domestic violence, dating violence, sexual assault, and stalking. So those federal housing that we talked about earlier that would be covered under the CARES Act, these would also be housing projects that would be covered by VAWA. So what protections are offered? You cannot be denied admission to a federally funded housing provider because you've been threatened or are the victim of violence or stalking. You cannot be denied federal rental assistance because you have been threatened or the victim of violence or stalking. You cannot lose your federal assistance or subsidy because you have been threatened or the victim of violence or stalking. You cannot be evicted because you've been threatened or the victim of violence or stalking. What we see sometimes is if a person has to make multiple calls because they're victims of domestic violence, the housing and landlord-tenant would say that, or the landlord would say that the tenant, we have a no calling police policy here, and the police have been to your apartment 3 times, so therefore we're going to evict you. That is a violation of VAWA, because it is not the victim's fault to calling the police. I'll say she most time is the victim of the violence. Therefore, she should not be punished and lose her housing because she's a victim of violence. Your housing authority or landlord is required to tell you all about VAWA housing protections when you receive assistance upon move-in, at recertification, if you're denied admission or assistance, or if your assistance is terminated, or you receive a notice of eviction, you need to fill out Form HUD 5380. You should not be afraid to go to your housing authority or your landlord because they are required to keep that information confidential unless disclosure is required to evict the abuser required by law or with your permission. One final thing I do want to go over with regards to fair housing is sexual harassment. And sexual harassment is an area under the Fair Housing Act that the Department of Justice and HUD have taken a very strong interest in and are actively pursuing cases for violations of the Fair Housing Act as sexual harassment. During COVID-19, we all know that people are behind in their rent, and those bad landlords, those unscrupulous landlords may go to a single mom and try and convince her to engage in inappropriate behavior in order to not have to pay the rent. That is sexual harassment. And if you believe you're the victim of discrimination housing like that, then that needs to be reported. And that can be reported through HUD, through Community Legal Services in Florida, or through the Department of Justice. There are several ways that you can be sexually harassed. One will be the quid pro quo, and that's what I just kind of referred to as, if you do this for me, I'll do that for you. If it's sexual in nature, that is a violation of the Fair Housing Act. Hostile environment is another form of sexual harassment, and that's when a housing provider subjects a person to severe, persuasive, unwelcome sexual conduct that interferes with the sale, rental, availability, terms, conditions, or privileges of housing or housing-related services, including finance.
The property manager persistently came on to me. He offered me free rent in exchange for favors and threatened to evict me if I refused.
I am afraid. He has a master key and lets himself in anytime he wants. As a single parent with young children, I can't afford to leave.
Sexual harassment is against the law. If you feel like you are the victim of housing-related sexual harassment, you are not alone. Contact us today.
Those last couple of slides with regards to VAWA and sexual harassment, especially with VAWA, if you're the victim of domestic violence, please reach out to the National Domestic Violence Hotline and the numbers up there, or the Florida Domestic Violence Hotline. Please get the help that's out there and that's needed. If you have legal issues with your housing, you can contact Community Legal Services Helpline. The number is 800-405-1417. And the hours are listed there. We do more than just housing. So if you have a legal issue, I would first recommend that you go to our website, which is www.clsmf.org. It has all the areas of law that we covered. You can do pre-screening there if you want. You can do an intake online, and we even have a chat function on there where you can chat with a lawyer during these normal hours of operation. So now I do have one question that was given to me after the first one, and that dealt with my AC has been out for the last 3 weeks. Does that count for reduction in rent? If so, how do I go about getting it? It does not count for reduction of the rent, but And as I talked about earlier, you might have remembered that under Florida law, the landlord's required to provide heat, but there's no requirement for air conditioning. But many leases here in the state of Florida do have a provision in there where they say they will provide you with working air conditioning. And if that is in your lease and that AC has been broken, you notified your landlord, then you would want to do that 7-day letter we talked about, where you're telling the landlord that I'm not going to pay my rent until you fix this air conditioner as outlined in that lease, and you have 7 days to fix it. So you would not get a reduction for your back rent, but you can withhold your forward rent, your rent going forward until such time as they fix it, if that is in your lease agreement. If you're unsure, once again, you can call Community Legal Services and talk to one of the lawyers there, and they can go over your lease with you and explain what your rights are.
Why is there no CARES Act funding for Seminole County?
Okay, I'll take that one real quick. I don't know. That's an easy answer. We deal with Orange County, and there is awards that are given out that you have to, I'm assuming, apply for. But I'm going to let Yesenia kind of touch on it real quick.
Why there's no CARES Act funding for Seminole County. Local governments are required to request this funding. So we ask for you to please contact Seminole County directly and see what other services they have available. From my understanding, the majority of the CARES Act funding was appropriated to all of the local governments. If Seminole County does not have any CARES Act funding, please contact your local authority.
Will late fees from landlords be considered during COVID-19?
Yes, if your lease agreement has a provision in there for late fees, and when we're talking about late fees, usually most rental agreements will say if rent is due on July 1st, if it's not paid by July 3rd, then you'll be assessed a $50 late fee, and some of them even go so far as wanting to give you daily fees. But if that is in your lease, then you have a contract with your landlord, so they can enforce that contract against you. So it is purely under their discretion as to whether or not they're going to waive that late fee in your rental agreement.
Can we set up a payment program for late rent? How?
I truly hope so. I think that is the best way to avoid so many of the evictions that we're afraid we're going to see once the moratorium is lifted. I'm going to kind of harp on this one more time, is communication. If you do have money that you might be able to allocate towards paying your back rent, and let's say that your job has been reinstated and you're back working again and you can pay your rent going forward, the best thing to do is budget your money. You need to make sure that you can pay your utilities, you can pay your insurance, you put food on the table, keep your utilities going, and then figure out how much money you can allocate towards that back rent and how much you haven't paid. But you need to make sure you have an accurate accounting as to how much they're trying to charge you for your back rent. That's the time when you can potentially negotiate waiver of any late fees. I think a landlord would appreciate you coming forward and trying to work out a deal. If you can get the agreement in writing, that's obviously the gold standard. That's what you want to do. That would bind both of you all to that agreement. You would both sign that agreement, but you need to reach out to your landlord first. I don't know if the landlord's going to come to you. They're going to send you probably a 3-day letter before they're going to send you a letter saying, hey, can we set up some type of payment plan for the back rent? So please reach out to them and try and get some type of agreement.
Can you be charged a pet deposit or pet rent for emotional support or service animals?
No. So long as you put the request in, and what you would want to do is you put it in writing where you're requesting a waiver of the pet fee, and sometimes it's a pet fee and a breed waiver waiver of restriction on the breed, but you put it in writing, and that's what's called the request for the reasonable accommodation. That is something that you can do. If you need help doing that, you can call Community Legal Services. There are other fair housing advocacy groups out there that can help you as well. It's not a legal document, but it is a request put in writing, and the landlord will either have to accept or deny it. If they deny it, then that's when I think you really need to reach out to fair housing organizations such as Community Legal Services to pursue your legal rights, because if you have a doctor's note and you truly need that support animal, we're here to fight for you to get that, because that is a protected civil right.
Does Florida have any special housing for families with children with disabilities?
I will say that there are a lot of nonprofit organizations working with local governments to be able to build more affordable housing for families with children and individuals with disabilities. Orange County specifically, we have the Housing for All initiative that was started several years now, and with the new administration with Mayor Jerry Demons, the Housing for All initiative is really building upon those strategies. We do have an action plan that has been approved, and within that action plan, Orange County will be allocating a total of $10 million on an annual basis towards the development of affordable housing for our residents. And those $10 million will be increased by 10% every year. So right now, we are working on putting together the specific guidance to that trust fund and working with developers, the public sector, private sector, nonprofits, to put together these alternatives that are going to assist us in building affordable housing.
Are there any volunteer opportunities with housing-related issues?
I know right now, Orange County, we have closed off our offices to the general public because we don't want the transmission of COVID to continue to increase. We want to be able to prevent it by any means necessary. There are a lot of food pantries that are going on in the community. My recommendations is for you to stay connected with your local commissioner. See what your local commissioner is doing, see what help they may need during these food pantry events. I know a lot of them are doing like drive-up events and stuff like that, so you can get more involved with them. Definitely reach out to some of your nonprofits and see how you can volunteer. Maybe you can't go to the facility to volunteer, but you can do something at home, right? So you can possibly put together some care packages. I mean, just please get in contact with these nonprofits and see what their current guidance is, because I know that, with the COVID-19, there may be some health concerns, things of that nature, and we don't want you to get exposed. We don't want our clients to get exposed. We want the community to be healthy, and we also want to continue to provide the services. So if you are interested, reach out to your local nonprofit organizations and stay connected with your commissioners in your district so you can be a part of some of those initiatives.
Will the Section 8 voucher waiting list be opened up?
Unfortunately, the Section 8 voucher wait list, it's already in place, right? So if it's going to be open, do you mean the application process? No, the application at this moment is not going to be open. We did open the application process several months ago, and we had over 25,000 applicants submit to be put into the lottery system for the wait list. Right now, we have about 800 people on the Orange County wait list, and as residents are exited out the program, either because they don't qualify no longer for the services, or maybe they're terminated based on violation to the program policies, then we'll continue to bring on those individuals that are actively on the wait list onto the program. I know that we are going to continue to strategize internally and seek technical assistance from HUD to see how we can best assist the individuals that are on that wait list.